Hello and welcome to this webinar on defending claims in Ireland in the current environment with myself, Ronan Cosgrove, a partner in Caytons here in Dublin, and my colleague John Sparks, a solicitor here in Dublin. The purpose of this, as you will see on our next slide, is to simply look at how one defends claims robustly, efficiently, and I suppose in a cost-saving manner, John, and how we as solicitors for defendants and insurers by and large, how we defend those claims efficiently and resolve matters expeditiously. The next slide simply discusses our firm. We're based in Dublin. We have a sister law firm in London based in Gracechurch Street. You may well be familiar with Caytons in London. Our experience is in professional indemnity. I have roughly 20 years in litigation, 10 years as a barrister, and prior to working here, I worked in an international law firm specializing in professional indemnity with my colleague John Sparks and dealing with a whole range of PL, EL, professional indemnity claims from a wide range of areas, which are, as we say, they're small cases but rarely simple matters. And we have a huge amount of experience dealing with these cases. And I suppose, John, what we have is we have worked in international law firms, but we bring that experience, but to a more boutique law firm with all that experience, but with an ability, I think, to get things done in a more efficient manner. So, John, I think you're going to have a look at the next slide for us discussing the Personal Injuries Assessment Board.
Yeah, thanks, Ronan. Yeah, so the Personal Injuries Assessment Board, otherwise known as PIAB, I think the first thing you'd say about PIAB that it's quite administrative in nature. It is a tool used by claimants when they have suffered injury, generally by public liability, employment liability, or motor accidents. PIAB's role, it's assessment only. It does not take into account any contributory negligence on the part of the claimant, nor does it take into account any, negligence on the part of the respondent either. So I think generally the process, if a respondent notifies PIAB of a claim or a personal injury, PIAB will then notify the respondent, or what then will become the defendant, of the potential claim. PIAB gives the respondent 90 days whether they can consent or reject to PIAB assessing the claim. If the respondent chooses to accept or consent to PIAB assessing the claim, PIAB will then provide a monetary value of the claim's alleged injury. This is done through the medical report that is annexed to the Form A, which forms part of the PIAB application, and also the book of quantum, which I'll touch on in the next slide. So generally, I think if a respondent consents to PIAB assessing the claim, the general kind of conventional wisdom would be that, there is an exposure of liability, or at the very least, there is an element of contributory negligence. And I think in that sense, I think PIAB is quite a good resource and tool because it provides, first of all, the respondent 90 days in which, as I said, they can consent or reject to PIAB assessing the claim. And in this 90 days, you can front load investigations on liability, you can talk to witnesses, you can look at CCTV footage, and then at the end of that 90 days or before then, you can then make an informed response as to whether there is an exposure on liability. And then just touching on the statute of limitations, because I know Ronan's going to be talking in a bit more detail later on, just with regard to personal injury. A claim must be lodged, a personal injury claim must be lodged within 2 years of the cause of action. However, there is a slight wrinkle within Section 50 of the PIAB Act, which states that the limitation period is paused when the claimant's application is running through PIAB and only recommences 6 months after an authorization is issued. So when an authorization issues, this allows the claimant to then issue formal proceedings through the legal process. So as I said, just touching on the Book of Quantum, the Book of Quantum is now from 2016. It replaced the 2004 book. So as you can tell or see, it took 12 years for the Book of Quantum to be updated. I think this was criticized by judiciary and also legal practitioners, for it to take 12 years for the book to be updated. I suppose the main criticism stems from the fact that the Book of Quantum it's a tool used by legal practitioners pretty much on a daily basis if you are in litigation, as a means to measure, defense cost reserves, what the damages may be with regards to claimant's injury. So for it to take 12 years for it to be updated, I think definitely possibly warranted criticism.
John, I think it's fair to say that every settlement meeting we're at, someone makes reference to the Book of Quantum to say, look, this is the scale the injury is on. It's either moderate, severe, minor, whatever happens to be.
Yeah, exactly.
So it really is the go-to book on trying to get a handle on what quantum may or may not be, depending on the nature of the injury.
Yeah, exactly. And I think now the book Quantum has to be, it's under legislation, the PIAB Act, that has to be reviewed at least every 3 years. So it kind of rectified, I suppose, that error of it would take 12 years to be updated. So now the book Quantum is separated into 6 different categories for the human body. There's 4 categories for the severity of injury, ranging from minor to severe permanent. And then I suppose just comparing them, the 2 books quite briefly, the more severe or permanent severe injuries, which are, I suppose, injuries you're less likely to see, certainly they're more rare. Generally, the quantum for them has remained the same, and in some cases, it actually has the kind of award of damages or the value of them has lessened. However, the more injuries that myself and Ronan would see on a day-to-day basis, the damages for those have actually increased. As you can see in the next slide, that the orange obviously represents 2016 and the red bar represents 2004. You can see a fractured nose has increased quite substantially, and also a shoulder fracture has again increased a reasonable degree. However, I think the most relevant and significant stat is the award of whiplash injuries, which has gone up by about 9%. It's just above the 15,000 mark for whiplash. And I suppose the reason this is so significant is 70% of the injuries that go through PIAB are motor injuries. So the vast majority of claims that PIAB see are through car claims. I think comparing this with the UK, I think correct me if I'm wrong, but I think the average award is about £3,000.
Yeah, I think you're looking at quite a big jump there in the Irish jurisdiction. Yeah, I think £3,000 is about right, give or take, John. One thing I think which is interesting, though, of course, is that the new Act did create more defined categories. Therefore, there may be an argument you made that, well, look, the old book quantum was a blunter tool within which to force the categories, and at least there's a greater degree of specificity as to whether it's chronic, severe, moderate, minor, however it falls on that scale. But you are right, when you compare the whiplash to the UK, it doesn't compare favorably, John.
Yeah, absolutely, yeah. So just giving, I suppose, statistical overview of the claims from 2018, these figures were released about 12 months ago, so we do anticipate the new figures will be released soon. However, they're still instructive as they do show, trends within Irish litigation. So the first statistic shows the claims registered in PIAB is close to 34,000, minor increase from 2017. As I said in the last slide, 70% motor, 80% public liability, 12% employment liability. So of the claims registered in PIAB, only 36% of claims consent to a PIAB assessment. So of this 36%, or 12,112, only just above 50%, so 51% of claims are accept the PIAB award. So you're looking at probably about 1/6 of the awards are actually accepted to PIAB. And I think the intention of PIAB originally, or the MO of it, is to lighten the load on the courts, and to provide swift and cost-efficient resolutions to personal injury awards. And I don't think PIAB would have, PIAB would have liked or would have foreseen such a low value of awards being accepted by PIAB. This could be for a number of reasons. One of them being the claimant and the respondent both have to accept the awards, and they may have, in either instance, they may or may not have been satisfied with PIAB's assessment. And then
one other thing, John, if you're being a little bit cynical, one could suggest that claimant solicitors are driving that, John, because of the fact that there's no costs award in PIAB, or rarely do they award costs, and even if they do, it's very minor, that it's not really in the interests of claimant solicitors to settle via PIAB. They want their day in court. They want to get that authorization and get proceedings issued. And as we'll discuss, probably in the circuit court, looking at the numbers of claims. But I'll let you deal with that.
Yeah, and then looking at the last statistic, 21,659 released litigation day one. So what this means that the respondent or the insurer or the defence solicitor have said, there is no negligence and there's no exposure on liability. So they've rejected PIAB's assessment, and it says you can go issue your legal proceedings and we'll fight this in court.
Well, John, the part of that 21,000, again, if you're being cynical, would be to suggest that maybe that's a plaintiff having a bit of a try on and seeing, is it worth my while? Because if there's no cost exposure to the plaintiff, he has a free go say, look, I'm going to sue you for a trip and fall or bad back, whatever it happens to be. And look, if they don't accept in PIAB, sure, nothing ventured, nothing gained. So there could be a bit of gamesmanship going on there by plaintiffs.
Yeah, it's fair point. Yeah, so just looking at the awards, PIAB awards over a broader period of history, 2010 versus 2018, you see fairly incremental increase across public liability and motor. Obviously, public liability, stuff that myself and Ronan kind of be our bread and butter, trip and slips in supermarkets, nightclubs, pubs. And you see, as I said, there's fairly minor increase there. Similar with motor average award, I've touched on it in a number of slides ago. Again, a pretty small increase. However, the most significant increases in employment liability average awards, as you can see, it is quite a big increase. I think part of the reason for that, I think, is that there's a huge duty of care on employers to their employees, to the point that it's obviously not, I don't think it's quite strict liability, but it's kind of getting quite close to that, Ron. I don't know if you agree with that.
Well, yeah, I mean, John, certainly we've plenty of experience dealing with, the injured back, the moving of pallets, the dragging of pallets for, large logistics firms. And yeah, they are difficult claims to defend, undoubtedly. However, as you know, good records is the only way to do it. And reviewing of systems at work is paramount. And invariably, you're going to need a good expert as well, of course, which we know all the guys around town on that one. But, listen, they're not the easiest claims to defend, but we will be showing the toolbox that we deploy to try and leverage pressure on both the claimant and his or her solicitor. Yeah,
I think just two more points to touch on. So the claims reported, which isn't shown on the slide, has increased from 2010 to 2018 by about 23%. It was just under 27,000 in 2010. Now, as you might recall from the last slide, it's nearing on 34,000. And then I think the other point, I think, which is actually quite important, is the figure which you can see on the left-hand side of that graph. See, pretty much, well, all of the claims, possibly by the EL, which is touching maybe just above 30,000, but they're all well within the circuit court range, which is 15,000 to 60,000. And that's where you want to keep them. Ideally, you want them in the district court, where costs are even lower. But you want to keep them in the circuit court where you can contain costs. If they start going up towards the 60,000 mark, that means in the high court, that means costs are going to get high. You really want to keep them away from that. So I think definitely one positive you can see from these slides is that they're, well within the circuit court jurisdiction.
Yeah.
Yeah, so it's just sticking with PIAB and looking at some legislative changes which have taken place within PIAB. So the PIAB Amendment Act came into being in April 2019. So, still pretty new, and ensures greater compliance with the PIAB process on the part of the claimant and also actually on the part of the respondent. So just touching on some of the key changes that are with the legislation. So a preliminary notice may issue to respondent notifying them of the claim. So as people may be aware, when a claimant issues reports a personal injury to PIAB, you have to have your Form A, which is kind of your kind of basic details, name, address, and stuff like that. Your Form B, which is your medical report, and also your fee. Often, believe it or not, claimants will forget or absentmindedly not put in one of those key parts of your application. So PIAB now introduced legislation where if a claimant does not put in one of those three things, a preliminary notice may issue to respondent notifying them of a potential claim. However, there is a slight nuance with obviously COVID-19 insofar as that claimants are now finding it quite difficult naturally to get medical reports. So PIAB have now waived the responsibility that has been put on the claimant to obtain a medical report when they have suffered a personal injury at the moment. However, they have to show that they have made efforts to get a doctor's appointment and that they will get one as soon as reasonably possible. Just touching on the next one, Ron, I think you were involved in this one case directly, so I might let you speak about it.
Yeah, well, this is an interesting case, Ronan, TNS Tavern. Mr. Ronan was a security guard in the Red Cow Hotel, one of the defendants, and a car drove into the front of the hotel, John, causing injury to him, the security or bouncer on the outside of a nightclub in the hotel. Originally, the concern here was, John, that one of the respondents, then defendants, was brought to PIAB within 2 years, however the second wasn't. And the question that the Supreme Court had to decide was whether the fact that you joined the first respondent to PIAB within 2 years and then joined a co-respondent, who then became the co-defendant, was your case statute barred against that second party against whom you didn't bring the case within the 2 year period. Bizarrely enough, in my view, they decided, well, the legislation wasn't particularly clear. On that basis, you could bring in that second party after the 2 year period. Now, what this act has done is has tidied up that anomaly. But on that case, I was only brought in on the latter stages of that case, John, when the file was transferred to us, because it was a book and run off, John. It was a case I wanted to get rid of. And we leveraged some of these tactics we're going to discuss to put serious pressure on the claimant and a solicitor to try and resolve that case in short order, which we did.
Yeah, thanks, Ronan. Yeah, so now with the PIAB Amendment Act, judges also have discretion in relation to costs for non-compliance with the PIAB process. So this may be in an instance where a claimant has not showed to a scheduled medical appointment by the respondent or the respondent's insurers or solicitors, or where the claimant or the respondent has not given documentation that has been requested by PIAB. So now the judges can issue a cost order against those parties for non-compliance. Finally, the PIAB may fast-track claims into the formal legal process. This may be an instance where the claimant is a minor of unsound mind, where in Ireland any damages award has to be approved formally by a judge, or also where a respondent has said very early on that they intend to fight the claim through court. So therefore, they are going to reject PIAB assessing the claim very early on. In that instance, PIAB will then fast-track it into the formal legal system.
It's positive, John, that any messing around in the PIAB phase is now going to be considered from a cost perspective down the line. It's very helpful.
Yeah, exactly. I think it's still quite early, as I said, April 2019 when it came into being, but any kind of pressure put on a claimant to not hang around with their claim is definitely a positive.
Yeah.
Yeah, so just moving away from PIAB and looking at the damages in Ireland. Yeah, so there's a change in monetary jurisdiction in 2014 with regards to courts. So as people may be aware, there's 3 different main courts in Ireland. There's the District Court, the Circuit Court, and the High Court. The District Court increased from 6,000 to 15,000, or just above 6,000 to 15,000, I should say. District Court, 38,000 to 60,000. And now the High Court has unlimited jurisdiction from 60,000 upwards. So I think that the original idea behind the change in 2014 with regards to monetary jurisdiction was to a lot of low value personal injury claims were going to the High Court. This is people perceived as a waste of the High Court's resources. So by changing the monetary jurisdiction, it allowed litigants greater access to the courts, and this will be facilitated by the District and Circuit Court. However, an unintended consequence of this was that this is borne out by statistics, which I'll show in the next slide, is that it actually increased the value in damages that were being awarded to claimants. However, and more positively, there has been a change in attitude within the High Court with regards to what people would perceive as the award of excessive damages. And I think at the centre of this kind of move away, or certainly change in attitude, is Justice Irvine, who is now president of the High Court in Ireland, but was a former judge in the Court of Appeal. And Justice Irvine had a lot of judgments around 2015 where she decreased or awarded significantly less that was awarded in the High Court through the Court of Appeal. And in Shamrock versus O'Sullivan in 2016, which I suppose would be one of Justice Irvine's landmark or kind of significant judgments, Justice Irvine referred to what is a notional scale of damages in Ireland, of general damages in Ireland, which ended at 450,000 being the max that could be awarded in Ireland. And I know, Ronan, as you're obviously a former barrister, you definitely would have dealt with Justice Irvine.
Well, Yeah. Well, when I was at the bar, John, she was a senior counsel or a QC, as we know in the UK, and she would have done a lot of defence work for insurers. So she would have seen some questionable, frivolous claimants. And I think that experience has shaped her view on damages generally, and I suppose how to deal with those kinds of claims. She's certainly a realist. She's definitely a pragmatist, and I think the way she looks at life is, well, look, if the worst case scenario, in other words, if the general damage is 450 grand, or as you suggest in the next slide, maybe 500,000 with the lower reform commission, that area anyway. If that's catastrophic, a bad back shouldn't be worth 80 grand. And that's the way she looks at it, John. And she is, I think it's pure experience working as a defence barrister that she has brought this now to the High Court and then the Court of Appeal, as you mentioned in the Shannon O'Sullivan judgment there, which is, it's great to have a dose of reality and ensure that claimants are kept on their toes when it comes to making claims and getting appropriate awards.
Yeah, thanks, Ronan. Yeah, so I think then the last final point on this slide is touch on the Law Reform Commission. So the Law Reform Commission is a body made up of esteemed lawyers and experts who provide recommendations on legal trends or what's kind of generally what's going on in the legal world or legal world in Ireland. So they published a paper at the end of last year in December, and they said, look, for general damages for catastrophic injury, it's 500,000. So obviously this is slightly at odds with what Mary Irvine had said. However, and there has been awards, to be fair to the Law Reform Commission, for 500,000. Nonetheless, I still think Justice Irvine's point is relevant. I think somewhere in between 450 and 500,000 is probably the sweet spot for the max for general damages. However, one cautionary note I would say is that this doesn't include special damages. So obviously for a catastrophic injury, special damages could also be quite high as well. So you're looking at things like loss of earnings, ongoing or future medical expenses. So 450 might be the word for general damages, but I said this doesn't include special damages, which also could be, really, really high.
Yeah, John, absolutely. And unfortunately in Ireland, periodic payment orders haven't really taken off, as you well know. But I suppose watch that space. But at the moment, those types of orders simply aren't very common in Ireland, but they may become more so.
Yeah, so just looking at the personal injury claims, 2017 versus 2018, as I said in the last slide, there has been a change in attitude in the High Court, 18.6 decrease. However, Circuit Court, District Court, there has been reasonably significant increases, and unfortunately they haven't fallen into line with kind of what the High Court's attitude, or certainly Mary Irvine's attitude anyway. However, I think, as I'll show on the next slide, hope is on the horizon with a number of changes that are afoot. And then just looking at medical negligence cases, again, a fairly minor decrease to 7.4%. These are cases, obviously involve misdiagnosis and stuff like that. And however, I think, Ronan, would I be right in saying medical malpractice case like Botox administration, negligence involving them, wouldn't be included in med-neg cases?
Yeah, no, med malpractice, IPL, laser treatment, microdermabrasion, Botox, as you mentioned, those kinds of things are going to fall within personal injury. And I think a lot of those cases, failure to do patch tests, failure to get consent, minor burns in the face, that's going to probably get you in the circuit court area. We have plenty of experience dealing with those, John, as you well know. But equally, we have plenty of experience dealing with med-neg cases or clinical negligence cases. A lot of those we see, certainly plastic surgery tends to be an area, bariatric surgery, that kind of a thing. And one concern we see is the fact that there are quite a few UK surgeons flying into Ireland for a weekend or 3 days, carrying out surgeries here and then going back to the UK. That can be problematic for many reasons, mainly because of a lack of consultation with the client and issues with consent and getting proper histories and all that kind of stuff. But the other problem from a very practical perspective, John, is that sometimes these guys aren't registered to practice in Ireland. And that is hugely concerning, particularly if trying to defend a case. Not to mention there may be issues on coverage there. But I think those statistics are very helpful and very positive. On the med-neg cases, John, of course, you never know how many cases are taken in a year, but certainly the global decrease is to be welcomed.
Yeah, and I think your point in the global context as well, like these statistics are important, but often they don't tell the full story because they obviously don't show cases that have been settled out of court and stuff like that. But
yeah,
I said it's great to see a decrease across all three courts of 14.2%. Yeah, so as I said, changes afoot, and hope as well that there will be more consistency with damages in Ireland. So the Personal Injuries Committee was established in April 2020. It's chaired by Justice Mary Irvine, who we've talked about in the last number of slides. So she's part of the committee, as I said, which is chaired with the following: to provide guidelines on appropriate level of damages and also to promote consistency in the levels of damages. And I think point two with regards to consistency is a really important one as a solicitor in Ireland, that damages awards are consistent in Ireland, because I think one criticism that could be leveled at the courts is the really inconsistent nature of the levels of damages are awarded in Ireland. So this really would be a welcome development if we could get a greater consistency in that regard. Finally, they're also tasked with establishing the principles for the assessment and award of damage to personal injury. So how they're marrying all these together is they're looking at jurisdictions like the UK and other jurisdictions around the world and seeing what damages are awarded, and therefore what is the appropriate level of damages. They're also in talks with the Personal Injuries Assessment Board, who I talked about in the first slide that I talked about. And so if these guidelines are approved, they're due to be submitted in October 2020. They're still on course for this, I believe, despite obviously what's going on around the world with coronavirus. And if they are approved, they will have the effect of replacing the Book of Quantum, which in Ireland this is a really significant change, to have the Book of Quantum replaced by these guidelines. And any departure from these guidelines by judges will have to be explained with adequate reason. So as I said, this is really significant, and for a judge to depart from these to have to explain any departure from these guidelines, it's a really high kind of bar, and it's a very high duty on a judge to have to explain why they're departing from any of these guidelines that are approved by Judicial Council.
Yeah, John, I mean, it reminds me of criminal judges departing from sentencing guidelines and having to give clear and cogent reasons for that. And of course, in so doing, they open themselves up to that appeal, which they certainly won't want, which just puts a bit of a straitjacket on some of these high court judges, which I think is no harm.
Yeah, exactly. So I think, I suppose the question from our point of view and insurers' point of view, is this a good thing? Absolutely. I think it's really kind of progressive, really progressive step. However, as I said, it's only established in April 2020, so it's really new. So we don't know obviously what's going to happen in the future or in the next kind of 12 to 18 months. However, it does seem positive, and one definite positive is that Justice Mary Irvine is at the chair of the committee, because as we talked about, she's a very common sense approach, very realistic approach, very pragmatic approach. So, I think with her as the chair, I think, we can definitely be somewhat hopeful that, these guidelines will be approved. Super
stuff. Yeah, I agree, John. The next slide, I think we're just going to have a look at legal costs on this one, John. Mm-hmm. And there's a perception in Ireland that costs are, we're an expensive place to litigate. Compared to the UK, there's no Part 36 offers. The procedure rules here are more akin to your pre-Wolf reforms, your old white book, possibly. Oftentimes, because of the lack of case management in a lot of courts, John, you need to issue motions to galvanize the claimant to take steps. And there's a tendency to settle on the steps of the court, and also an over-reliance on counsel. But of course, that's not something we do, John, because obviously with the amount of litigation experience we have in this firm, reliance on counsel, we keep that to a minimum. And I've never really understood why it's necessary to get counsel to draft motion papers. It's not cost efficient, and it's not efficient full stop, particularly when the solicitor knows the file inside out. We talked about issuing motions. There is a cost, obviously, John, in issuing a motion, but as you well know, minding a file in itself can cost money. And part of the reasoning for issuing a motion is to get the claimant to act, to take the next step in the litigation. But also, it means that the claimant's solicitor has to take steps, which of course cost money. And if you're dealing with a claimant who's reticent, spending money is not something they want to be doing. So our entire approach, John, is trying to find that weakness with the claimant, whether it's the case, whether it's costs, and trying to leverage pressure into that area. And if we can talk directly to the claimant, albeit through the claimant's solicitor, that's what we want to be doing, because we want the claimant to be feeling the pressure of the litigation, because oftentimes they don't feel that, John, and we certainly want them to be aware of it. the last point there is there's no fixed recoverable costs as per the UK in most courts. In Ireland, in the district court, you mentioned this earlier on, John, where you were awarded less than 15,000, where the claim is held in the district court, in one of the lower courts, there is scaled costs which are similar to the fixed costs in the UK. But once you get outside of that into the circuit court, then there are no fixed costs or scale costs, and they go to something called taxation, which again is quite an antiquated system, John, and in itself can be costly. When we're talking about settlement agreements, we'll touch on that again. But yeah, our job, John, having worked in big law firms, international law firms, is we're aware of where the costs can go in these cases, and our job is to limit those costs as much as possible and get things settled or resolved quickly. The next slide, John, we're looking at is just, once you get that authorization from PIAB, what happens? Well, first thing is, if there are co-respondents, now co-defendants seek an indemnity, particularly if it's multi-party. If you don't give a liability, write your letter, say, look, if you don't indemnify us, you're going to be not only on for the plaintiff's costs or the claimant's costs, you're on for our costs as well. And I think, John, it's fair to say, if you're dealing with a defence solicitor who acts in the area of insurance or is generally in the defence side of things, they will potentially have their own report on liability and they'll know where they stand. And if there is, oftentimes what may be a minor contribution from our client will be outweighed by the costs in seeking that. And we make it very, very clear to them that that's the position. We met with statute of limitations, John, we'll discuss, but you mentioned 2 years for issuing PIAB. If they haven't issued their claim within 2 years to PIAB, they will still get their authorization, oddly enough, but they won't be able to litigate because they're out of time. Identify any third parties, join them to proceedings. If you think there's anyone else who's potentially a mark or potentially negligent. And we mentioned just the Civil Liability Act down there and concurrent wrongdoers. This is a situation, John, there's a Civil Liability Act in the UK where, not dissimilar, there are some minor differences, but the difficulty here, John, that we see certainly in professional indemnity cases with engineers, construction professionals, whatever happens to be, architects, that if an architect and say a contractor are responsible for the same wrong, and that contractor unfortunately goes bust, which we see in recessionary times quite a bit, then if the architect is 1% liable or more, as the case may be, but even if it's only 1 or 0.1% liable for that wrong, he will be held accountable for all of that wrong as against the claimant. And then the claimant can get all the money off the architect, who is insured, professional indemnity insurance, and then the architect then has to go after the main contractor, John, which when that main contractor has gone bankrupt or left the country, whatever happens to be, it's a very unlikely recovery. So that 1% rule is something we always note in any kind of professional indemnity claim invariably, because it tends to operate. The next slide, John, we look at just dismissal of claims. And, there was a time, John, in Ireland where it was very difficult to dismiss claims, certainly a lot harder than the UK, where timelines are very specific and rigid. However, we're beginning to see some willingness from the judiciary to strike out or dismiss claims because people are sitting on their hands. We've discussed this already, John, about the cost of managing a file. Simply watching the file costs money. It's not a nice thing to have to say, but it's the reality, John. So, we want to be pushing the file, because that ultimately will result in a quicker resolution, and in so doing, clear up the insurer's books, but also reduce the cost, one hopes. But the principle set down in this case, primor is the case, is when the claimant is prosecuting his case, John, has there been a delay, and is the delay inordinate? Is it inexcusable? And then the judge will look at a kind of a global picture about where does the balance of convenience lie. And the next case we're going to look at, you might have a look at this one for us, John, it's a personal injury case. Tell us a bit about this.
Yeah, so it's around this personal injury case. So I'll just give you, I suppose, a whistle-stop tour of the timeline. So April 2011, PIAB authorization was granted, proceedings issued in November 2011. March 2012, first named defendant delivers notice of particulars in defence. So at this stage, I think everything's ticking along nicely in terms of, it's within time. There's no undue delay or anything like that. However, there's 2 years that in February 2014, the plaintiff replies to the notice of particulars, and then in March 2017, so nearly or just over 3 years, the plaintiff serves a notice of intention to proceed. So a notice of intention to proceed is a document that has to be lodged in the court's office where there has been no activity in a case for a period of 12 months. So it has to be lodged, as I said, in the court office to recommence the proceedings. However, again, nothing happened for until January 2019, and this is when the defendant lodged an application to dismiss the plaintiff's claim for want of prosecution. So just looking at the next slide, we're going to look at the principles that Ronan had talked about, the primary principles in relation to that, the case involving Anita Hadfield. So was the delay inordinate? Well, nearly 2 years between the delivery of defence and the notice of particulars and the replies to those notice of particulars. Then it was nearly 3 years between the receipt of those replies to particulars and a service of notice of intention to proceed. So I guess when it was all said and done, there was basically 5 years where the only active step that the plaintiff really took with regard to their own case was the replies to the notice of particulars. Yes, they served a notice of intention to proceed, but that was only because they had to do it. It wasn't really to do with the actual kind of the case or the liability itself. So was the delay inexcusable? Well, they gave no reason for the delay, so yes, it was. Where did the balance of convenience lie? Well, because it was such a delay, the issue of facts is hard to determine. So the actual injury itself happened in 2009. The application to dismiss was in January 2019. So that's 10 years between the application to dismiss and the injury itself. So how can you ask a potential witness to provide an accurate testimony of something that happened 10 years ago? Even with the best will in the world and the best record keeping you can have, it's still very hard for a witness and to ask a witness to give really accurate testimony. So the judge was then satisfied that, I suppose, on the bounds of justice, that these proceedings should be dismissed for want of prosecution on the grounds of inordinate and inexcusable delay. And one other thing the judge noted as well, that the delay should also be looked through the prism is in that the plaintiff or the claimant just lodged their claim just before the 2-year statute of limitation expired. So not only did the plaintiff delay when legal proceedings issued, they also delayed in actually bringing their claim to the court. So as I said, the judge then was satisfied to dismiss the claim.
John, I mean, we've seen these. I mean, it's very positive that the court is now. I see these quite a bit also in multi-party cases, John, where one or more defendants bring this kind of application, put pressure onto the plaintiff, who's clearly uncertain, unclear about their case, whatever it is. And there's two outcomes invariably. Either they capitulate and they ring you up and they say, look, what can you do for me here? I said, look, well, we might walk away if we bear our costs or whatever happens to be. The other option is you run it and you get it dismissed. But it's a very useful tool on a couple of points, because it once again gets the claimant really worried about his or her case, and the claimant solicitor very worried about his or her case, because the claimant solicitor is sitting on their hands. There's potentially a negligence claim against that solicitor also. So all about getting skin in the game for the various actors and getting them worried, John. That's what we. The next slide, I think, we look at the statute of limitations. Particularly remarkable here, 2 years for personal injury cases, as you mentioned. That 6-month window, of course, after authorization is a standstill period from the personal injury assessment board, which of course is just written only. There's no witnesses in the personal injury and no costs, as you mentioned. Tort and contract 6 years, although 12 years under seal. There's some wiggle room with minors where the statute of limitations doesn't start until they reach the age of majority. There are some nuances with child abuse claims, John, as you know. Jimmy Savile cases, for example, where the abuse only comes out quite a bit later. The court may operate a slightly less rigid view on statute there. And one other case which would be of interest to anyone involved in professional indemnity, and particularly construction, a Brandley and Dean case in Ireland is the real case on when the statute runs for construction cases, and it's 6 years for the manifestation of damage, or when the damage could have been fully appreciated or appreciated. There's no Latent Damage Act here in Ireland, so slightly different statute of limitations regime here in Ireland as opposed to the UK. The next slide we look at here, John, and we're talking about the Mediation Act. This is something, John, that I suppose there was a slight opposition. Certainly when I was at the bar, there was a feeling that mediation really wasn't the way forward. But I think it's beginning to take on a bit more traction. People realize the sense in it. the potential cost saving. And this new act introduces some very interesting requirements on the solicitors, that they must advise their client in the cases where it applies to consider mediation as a means of attempting to resolve the dispute. John, one of the first things we do is to write a letter to the side, say, have you advised your client about the benefits of mediation? Because then they have to advise their client. And once again, it's the claimant himself going, what's this mediation business? What, I can settle the case sooner? Is that what you're saying? You know, it gives a chance, John, of getting the case resolved before all of those heavy costs like discovery costs or disclosure costs, and then down the line even further when you're at trial and you're bringing in counsel. So anything which gets people talking sooner rather than later, particularly if there's a small liability, means costs are going to be capped to a certain amount, and that's always very, very helpful. One interesting little wrinkle about this act is that if they don't advise them, your action can be stayed, because there's a duty on the solicitors to put in a sworn statement to say that they have in fact advised their client. If they don't do that, the case can be stayed. But yeah, it's encouraging that this is beginning to take more hold in Ireland. Certainly construction cases, very, very positive. Multi-party cases, John, where you've got pleadings flying around between the various parties. It cuts through it all, gets people into a room, gets them talking, which is obviously sensible. The next slide we're going to look at here, John, section 26, one of my favorite slides, John, this one. This is an application you can make where a claimant has made a case and he is knowingly misleading the court or giving false evidence. Essentially, he's lying, it's dishonesty, it's deceit, or it's gross exaggeration, which would amount to that. But fraud, John, you know, it's civil fraud. And this isn't the little white lie, John. This isn't the minor exaggeration. This is a clear exaggeration and a clear intention to defraud the defendant and or the insurance company. We've been involved in a couple of these Section 26s, John, and what we'd always do is when we're threatening that Section 26, we would write with that letter, say, look, we're going to bring this application, and by the way, we're going to have the Director of Public Prosecution send a representative there, or a member of the police to be present in court to take notes, because we want to see you potentially suffer a criminal conviction for fraud. That really does put, put some fear into the claimant and the claimant solicitor, probably less so the claimant solicitor, but the claimant is advised that, look, if you're lying about your case and it's shown to be a lie, you could end up with this criminal prosecution. That's a lot more than a claimant bargains for when he sets a hair running and tells, you know, a little white lie, a little porcupine on his pleadings. And what's interesting there, John, is that under the new legislation, every time a pleading is issued, you have to file something called the affidavit of verification. So you have to read it and swear that what's in it is true, whether it's your original writ or your replies to particulars. Now, this is a change from 04, because prior to then, most claimants would simply say, well, look, I didn't read the papers, John, or, you know, my barrister drafted them. You know, I don't really talk to that guy. But this means you have to read them and you have to swear as to the truth of them. And this really, we were always asking, putting that pressure on the claimant. We want that affidavit of verification. And I think it's, you know, clear in correspondence when you have when you're demanding the affidavit of verification, it's fair to say you can read between the lines that we might have a sneaking doubt that there's something questionable or something fishy about the claim. And there's a couple of cases here we mentioned. One is Platt v. OBH. In this case, Mr. Platt fell out of a hotel window, suffered quite serious injuries, John, suffered injuries to his back, hip. His injuries were serious, but the way he portrayed his injuries were chronic. He was in a wheelchair. Surveillance footage then showed him, John, you know, getting in and out of car, walking around a shop, albeit with a crutch, to be fair. But the way he portrayed his damages, he was looking at around 300, 350. His damages were probably only worth 80, John. Now, this is the funny thing. He did have an injury. He did suffer an injury, John. He just exaggerated it to such an extent to the medical professionals, who arguably in this case, as the judge said, need to be a bit more discerning in their medical report. They need to ask the right questions. That's good as well. The medical professions are not allowed to be complicit in this. But in that case, he did have an injury. He simply lied about it. And the court said, you're clearly trying to defraud the insurance company in this, and struck the case out with costs against him. There was another case involving a fellow who said he had no loss of earnings or had claimed a large amount of loss of earnings, but then was discovered to be a ticket theft. And they're the kinds of facts, John, that you can't say it was a white lie. Well, it's either true or it's not true. And you either lost 100 grand from loss of earnings or you didn't. That's the beauty of this. As you and I, John, know that surveillance is key in these kinds of cases. We've seen cases with people with terrible bad backs who can never work for the rest of their life, and then we see them all fishing off the west coast of Ireland, jumping off wet rocks like a billy goat. That clearly doesn't tally with the medical records. Now, the difficulty we also have, John, there sometimes, as you well know, is that they may claim it's a good day, but certainly, in my view, any of those bigger cases that we're involved in, where the specials are getting into, you got actuaries involved, vocational assessors, whatever else, that's when the surveillance comes in very, very handy. And there is an art form, in my view, to it, but it's money well worth it. And I know one of your favorite things, John, is the social media as well. I mean, you'd be surprised what people will do on social media. We mentioned a couple of cases there. The Iosca case there, that involved a conspiracy to defraud the MIBI, who are the uninsured insurer, and they step in if a party is uninsured. In that case, he's been criminally prosecuted, John. The last case there, Les Markham and Ronnie Dearman, two brothers, different names, oddly enough, but they are two brothers. And that was only quite recently, where the DPP, or the Director of Public Prosecution, the Crown Prosecution Service, is bringing a case against them for fraud. And then the other case there, Miss Pineda, she remarkably, not quite fraud, but in that case, her case struck out because up on social media, she had a picture of her doing weights a couple of months having a car accident where she alleged serious injuries. I mean, remarkable stuff that you can get on Facebook, Instagram, whatever else. And that's, a pretty basic search, but, never underestimate human nature. It's remarkable, really. But this is very, very positive, John. It can go by way of pre-trial motion, Section 26, and you will need evidence, John. You will need surveillance footage or something akin to that, or a classic one. Have you been in previous accidents? No. Have you brought previous proceedings? No, you haven't. And then we find out that they've been involved in 3 or 4 different cases, similar road traffic accidents. That's the kind of stuff that judges will love. So yeah, there is undoubtedly a turn to an acceptance. This Section 26 application is an important part of our armory as against questionable or vexatious or fraudulent claimants. The next slide we look at, John, Section 17. Keep this one brief. This is a lesser known section in the 2004 Act, and it simply is a letter that you send out to the other side and say, look, what is your settlement terms? Most plaintiff solicitors don't know this section, and it once again puts the question to the claimant, because the claimant solicitor must go to the claimant, how much are you willing to settle this case for? The claimant probably doesn't really know, but at least we're getting them thinking, John, about costs, about quantum, because this notice can then be shown to the judge after the award on liability, and they go, well, look, we offered them, we asked them what the settlement, what their number was, and they didn't get back to us. So all of this is about putting pressure on the claimant and the claimant solicitor, because the claimant solicitor, of course, is very interested in costs. Now, the next slide, John, is tenders and or Part 36 officers that are in the UK. This is absolutely vital. Every single defence solicitor should be employing these as smartly and as cleverly as possible. This is an offer, John, which you make. If the claimant does not beat this offer of, say, 20 grand you offer, the claimant doesn't beat that at trial, from the date you make that offer, the other side will be paying your costs. Hugely important. Imagine how embarrassing it would be for a claimant solicitor to say, well, we won the case, we got 19,000, but we have to pay all their costs because of this tender offer. It puts so much pressure on a claimant solicitor that, it's almost like calling, are they calling bluff? It's a bit of a poker game to some extent, John, but naturally, when it comes to poker, we know our book of quantum inside out, we know judgments, we know where liability sits. So our ability to value claims really comes in handy here, because we say, look, this is a very solid competitive offer. And the other thing, John, is that you can do this quite early in proceedings. You can then top it up later in the proceedings. So at that stage, you may have discovery or disclosure of the medical reports of maybe their medical records, and say, hold on, they've got this pre-existing in here. Or maybe they don't have pre-existing, but they have this other side injury. Add it up by another couple of grand. then that's the date. If they don't beat that new offer of say 23,000, all of a sudden they're paying your costs. And as you know, John, a lot of the costs in Ireland are backloaded towards the trial. So, instructing barristers to run a case, preparing for trial, expenses, attending court, at least with court when we did physically attend court, which we will again, no doubt. But all of those are the kinds of things. But this tender offer leaves no discretion for the judge, John. That's the key thing. If the judge awards you 19,500 and you provide a tender of 19,507, you've beaten the award and you will be getting your costs. No discretion. Hugely important. And the fact that you can top up as well. The next one is a Calder Bank letter, which people listening may be more familiar with. This unfortunately does leave some discretion to the judge, but a well-crafted Calder Bank letter explaining why you think their case is only worth X amount and your willingness to offer X amount. Once again, it'll only be shown to the judge after the case is resolved in liability. But when it comes to costs, you've got your Section 17, you've got your tender, and you've got the Calder Bank. The tender is the strongest because it leaves no discretion to the judge. The Calder Bank is also a helpful one. And a carefully drafted Calder Bank, once again, puts so much pressure on the claimant solicitor that he may or may not get, he or she may not get their costs at trial, that all of a sudden they're picking up that phone to you and saying, look, how much is this case worth? And if there is an exposure and liability, John, shutting the case down and avoiding those potential cost issues and cost consequences, particularly for discovery or disclosure and counsel's costs, it's a no-brainer. Particularly if it's in a lot of those heavy cases around 20, 25,000, where a lot of cases in the circuit court are sitting. Shut them down early if there's an exposure and get the cost. Only, of course, if you haven't got a defence to the case. And then the next slide, John, we look at is settlement agreements. Yeah, the most important thing, John, is often just picking up the phone. That'll sometimes get a case settled quicker than any pleading. But all-in offers, that's where we say, rather than saying, we'll give you, 20,000 plus costs, we say, look, we'll give you 24,000, that's it. And you can work out the costs amongst yourselves. So the claimant then has to have that conversation with his own solicitor about how much of the 24,000 goes to the claimant solicitor. And it's a very attractive way for a claimant solicitor to settle a case. It's attractive for us as well because we don't have a big argument about costs, about how much it's worth, because we don't have that fixed scale or scaled costs in the circuit court, John. So anything over 15,000, there's a degree of discretion. We've seen a lot of people trying on, this case is worth 5, 6, 7,000 euro costs. Well, show us your file, but based on our file, there's been little correspondence, little engagement, and the case is settled early, so we don't agree with you. So settling before the costs increase, before disclosure, settling before instructing counsel, hugely important. One little trick that certainly I don't think is particularly well known is where, John, a claimant has made a claim for loss of earnings because he's been out of work or she's been out of work for a period. During that time, he or she may be getting social welfare benefit or as it's known in the UK, a CRU benefit. Now, in Ireland, there is a duty on the defendant to pay back the revenue, whatever money was paid to that person due to loss of earnings or inability to work. Now, there is a way around that if in your settlement agreement, the claimant agrees to waive his or her loss of earnings claim. If he's not making a loss of earnings claim, John, why would you have to pay any loss of earnings benefit to the state? It simply follows. Now, hugely important, particularly if there's a claim there to the revenue for 4, 5, 6,000, John. That all goes with the stroke of this settlement agreement. Now, one note of caution is that one shouldn't be entering into such agreements if the sole purpose is to, I suppose, get around that revenue payment, because there might be a perception that you're trying to do that. But certainly we've used this quite a bit, and there is sense in it, particularly if the loss of earnings claim has limited benefit. Or you might simply say, look, your loss of earnings claim is only 25%, we'll pay 25% of your CRU or the RBA payment back to the revenue. So it is a great way of getting out of a liability which you will ordinarily have, but once you get that settlement agreement and get it ruled, there could be a very, very good saving there, John, and not something that's very well known.
Yeah.
The next slide we're looking at, John, I think are challenges that we are facing now. We're in late July. COVID-19 is still what it is. Hopefully things will change, but this is the current landscape. John, do you want to take us through a few of these issues?
Yeah. I don't think I'll spend too long on this because I think, as you said, Ron, the situations continue to evolve as the courts in Ireland, as there is more footfall, as they have reopened. You know, everyone who has attended has to adhere to all the relevant government guidelines, such as hand washing and wearing masks in court, unless addressing the court directly. And myself and Ronan have been involved in a couple of remote trials. I think generally they've run pretty smoothly. However, there generally have been more kind of uncontested hearings rather than where a witness might be providing oral testimony. In the lower kind of the circuit court, in the district courts, which I've mentioned previously, obviously a lot of cases were adjourned from March. Now these are they have recommenced hearings really since June. So they're kind of getting up and running with physical hearings where possible once both parties are able to adhere to social distancing and all the other relevant guidelines. And I think the main, challenge with regards COVID-19 is there is an opportunity to actually settle existing claims from our point of view, which is, I suppose, one small positive. And one thing that Mary Irvine, who of course we've mentioned a number of times, has said, and I think she stuck her head above the parapet, which potentially has gone beyond her jurisdiction as a judge. She has said since March in the High Court, there's 320 cases that have been adjourned for hearing. And she also said that generally with personal injury claims, that cases are given a date for hearing. Only 11% of these cases actually go to full trial. So 89% of cases are settled. So obviously of the 320 are included in this, would be included in the statistics. So what Mary Irvine said has encouraged plaintiffs and defendants to speak to each other and settle these claims as soon as possible. Of course, only in a situation where they should be settled. She's not asking anyone to settle claims that shouldn't be settled for, or asking plaintiffs to settle claims on behalf of their client where they believe they might have a better chance of getting a higher award at trial. What she is saying, it speaks to social justice for people to pick up the phone and speak to each other and get the right result for their clients.
John, that's precisely what we do. I mean, it sounds a little bit like trying to settle a case before Christmas, John. That kind of a thing, to be fair. But certainly, our MO is always to try and settle these cases over the phone where possible. And she has simply reinforced that. That's the way to do it. Because if only 11% are actually going to trial, what are the other 89% doing? Why are we settling so close to trial when clearly we can settle before then? So I think it's very, very positive. I think we can use this backlog in cases to say to the other side, look, do you want to settle it now, or do you want to wait another 9 or 12 months? So they haven't factored that into their costs, the claim. So there's definitely, there's a possibility, I think, that we can get things sorted even sooner than maybe we would have hoped. So I think I agree. There is an opportunity there despite the difficulties within the courts. The next slide, John, I think we just list a few cases which the people at home can read in their own time, but it's all just showing that there is a tendency or a greater appetite by the courts to reduce damages or indicate that there's no liability in certain circumstances. And I think it shows a degree of greater understanding, greater practical common sense applying to some of these cases. And that is certainly welcome for our insurer clients. And I think the next slide, John, is just us, I suppose. We'd like to thank everybody, I suppose, John, just for hopefully listening to this. Hopefully they found it informative. And any issues or any queries, they can go to our website at caytonslaw.com or contact us directly. So we hope you found that informative, and we look forward to seeing you when we may see you. So thank you very much for listening. And John, thanks for your help.
Thank you.